Derek Chauvin still on trial. Today is day 20. The government is still presenting its case in chief. And so let's take a look at our trial board to see what was going on today. Move myself over here to the left. Today we had a lot of activity from three different prosecutors. One, Steve Schleicher, who was really handling most of the witnesses this morning. Mr. Matthew Frank was handling most of the government witnesses this afternoon. And then we saw this woman over here. I still don't have her name. I'm going to get that, though, at some point and update my slide. And she was handling the last witness of the day. Then we saw these individuals testify. So we have the use of force expert, which Jody Stiger was the person who was testifying at the close of the day yesterday. And then first thing this morning, that was followed by another use of force expert, have a little bit from him. Then we spent some time listening to this woman who is a vehicle forensics person. So she's an expert. She was responsible for processing the vehicle that George Floyd was in, as well as some of the squad car that they tried to get him in near the conclusion or about the middle of the incident. Then we hear from the government chemists. And so this woman came in and talked about these magical pills that they found that suddenly, sort of like came out after a second round of inspection by government officials. And then we also have this private chemist who closed out our testimony today. And so we've got a lot to get into. And I want to start off by discussing the gentleman that we started hearing from yesterday, Jody Stiger, I think is how you say his name, and he is an expert witness from LAPD. And so they brought him into court yesterday, and he is sort of this private expert witness that the government has hired to come in and say, hey, what's your opinion on a lot of this use of force stuff? So he was testifying a lot yesterday, and we're picking up today based on what he's doing is he's walking us through a lot of these policies and procedures that, kind of police agencies across the entire country follow, because we have one Supreme Court, one Constitution. And so you can't have a police department that runs their department like the United States and another one that runs themselves like China or something, right? They would be in violation of the Supreme Court rulings. They would be in violation of our Constitution. They're not equal. So they all sort of have this, they stem from the same origin. And so this guy comes in, he's not part of Minneapolis or Minnesota in general, but they bring him in from LAPD. He's a use of force expert, and he's talking about this case called Graham versus Connor and these different factors that are incorporated into police manuals and use of force procedures and things like that. And so we're picking this up with that conversation. And so what is happening right now is this prosecutor, Mr. Steve Schleicher, is now asking him questions. This is the direct examination portion of this trial. So these are friendly people. This is the government's witness. This is a government prosecutor. And they're asking questions. And what you're going to see him do is pull up literally a screen from the manual, from the Minneapolis Police Department use of force and the code of conduct manual. So they're going to look at a document, and then this prosecutor is going to clip out a specific part. And he's going to say, hey, well, what about these three things? What about these three factors? And I want to just frame out sort of what's happening in his mind or behind the scenes just a little bit. So in law school, there's a concept that we talk about when we do analysis, when we're analyzing legal issues. If you're a lawyer, if you're in law school, you know what I'm talking about. You know where this is going. It's the IRAC formula. And many people, Iraq, what, like the Middle East? No. IRAC. It's an acronym for doing legal analysis. And so the I stands for issue. What's the issue? What are we talking about? R stands for the rule, A for the analysis, and C for the conclusion. And so this is just kind of a very simple framework that you are sort of taught when you're presented with a difficult legal question that needs some analysis. You say, okay, well, what's the issue? What are we talking about? Well, in this case, in the George Floyd case, we're talking about the cause of death. And in this witness in particular, we're talking about use of force, excessive force, objective reasonableness, and those types of legal concepts. And so what they're talking about here is basically what we're going to do. What he's going to walk this witness through is an analysis based on three factors. So they're going to talk about these three excessive force factors, and they're going to say, okay, if the issue here is whether Derek Chauvin used excessive force, how are we going to analyze it? That's the issue. That's the I in the IRAC. Well, what are the rules? So how do we determine whether he did actually use excessive force or he was in violation of their internal policies and procedures? How do we analyze that? Well, we look to the rules. The issue is, did he violate it? The rule is, well, where do we look? We look to the manual. We look to the book that they have on this thing. And so that's exactly what Steve Schleicher, the prosecutor, is doing. He's going right to the rules. And you're going to notice in this next clip that there are three different rules. There are three different guidelines or three different factors that they're going to apply or analyze, which is the A. It's the application of the rule to the facts. It's the analysis portion of it. And so he's saying, okay, we know the issue is about excessive force. We know the rule is one of these three things. How about the analysis? And so this witness is applying the rules to what happened back on May 25th of 2020. And then you're going to see at the end, he gives us a conclusion. And so we have three different factors that he's going to do a very quick analysis on, and he's going to take every one of those sort of those mini analyses and draw a conclusion that answers the issue. IRAC, issue, rule, application, or analysis, and conclusion. And so he's going to do that very briefly. Then what you're going to see is Mr. Nelson come back out and really expand the scope of this thing. Remember how many times we've talked about the scope, about where both sides want this to go. Here, the prosecutor is saying, oh, look, we have three rules, we have three guidelines, so that's it, right? That's it, you're done. Did he do that? No. Did he do that? No. Did he do that? No. All right, so our analysis means that Derek Chauvin did in fact use excessive force. Nelson comes back out and says, no. It's not just those three rules. This is a way bigger thing than just that. And I want to show you how he does it. And it's pretty dang masterful. So this is the prosecutor who's going through this framework with this witness. Let's take a listen in.
I believe it's
so there's the form.
And highlight the three bullets on the middle of the page.
Now at the very top, it says
from the Minneapolis
Code
Police
of Conduct,
Use of Force Policy and Procedure Manual, Section 5-300 series. Is that right?
Yes.
There it is.
And you see the different Graham versus Connor factors outlined here that you previously testified about. True?
Yes.
Now, you've already spoken as to the first factor, the severity of the crime at issue. Did that change during the restraint period?
No. The crime was still that Mr. Floyd was in possession of a fake $20 bill.
So I'd like you to focus then on the second factor, that is whether Mr. Floyd posed an immediate threat to the safety of the officers or others at the time during the restraint period.
No, he did not.
And why not?
Because he was in the prone position, he was handcuffed, he was not attempting to resist, he was not attempting to assault the officers, kick, punch, or anything of that nature.
Did he ever communicate an intent to do so?
No, he did not. I didn't hear any verbalization of any threats towards the officers.
Did he ever indicate whether or not he had the ability to do so?
No, he did not.
Can you comment as to the number of other officers on the scene present at the time and how that would relate to any opinion you have regarding whether Mr. Floyd presented a threat?
Yes, so another factor that's considered when evaluating a use of force is the number of officers versus the number of subjects. In this particular instance, there were actually 5 officers on scene, 3 officers that were using body weight on Mr. Floyd, and there were 2 additional officers that were on scene as well.
And in terms of the threat, there's a descriptor here, and that is it needs to be an immediate threat. Is that right?
Correct.
And so on your analysis, Mr. Floyd, in order to pose an immediate threat, would be able to presently cause some sort of harm. Is that correct?
Yes, immediate meaning it is happening right now.
Now, focusing on the third factor, and that is whether Mr. Floyd was actively resisting or attempting to evade arrest by flight. Could you describe to the jury your analysis as to that third factor?
Based on my analysis, Mr. Floyd never was not actively resisting at the time that he was in the prone position, nor did he communicate to them that he was attempting to resist or evade them.
All right, so pretty easy, right? Pretty simple analysis. He says what the issue is: excessive force, use of force, violating of police departmental protocols. What's the rule? Goes through, and you'll notice, right? You may have missed that, so I wanted to give you a little bit of a heads up. But he said, okay, let me open up this document. Go to the second page, and he just goes right in and he highlights the 3 bullet points that he referenced 3 times. Goes back, says, well, what about severity? Did the severity of the crime get any worse? Well, no, not really. George Floyd, allegedly, the initial crime there was counterfeiting, submitting a counterfeit $20 bill. That didn't get worse as this unfolded. Now, you could argue that maybe it did. Maybe there was some additional disorderly conduct or an additional resisting arrest charge. So you could actually make that claim, right? You could say that there was a series of new crimes that were committed. When he did not get into the back of the vehicle, he was refusing a lawful order, disobeying a police officer, however they phrase it there. Now, he's saying it didn't get any worse. That's fine. I don't want to, have qualms about that. But you could make the argument the other direction. He also says, was he an immediate threat? No, he wasn't an immediate threat, right? That's another rule. That's a second rule. Immediate threat? No. I mean, he could have been until he was in handcuffs and he had 4 officers laying on his back, but he was no longer an immediate threat, right? So, okay, great. We got that one. Now we move on to the next one. Was he actively resisting? Well, no. I mean, he passed out after about 4 minutes. He wasn't, even conscious anymore. So obviously that factor doesn't fit either. So should he have been using any force at all? Well, not really, right? According to this next statement. Here he is.
Sir, do you have an opinion to a degree of reasonable professional certainty how much force was reasonable for the defendant to use on Mr. Floyd after Mr. Floyd was handcuffed, placed in the prone position, and not resisting?
Yes.
What is that opinion?
My opinion was that no force should have been used once he was in that position.
Okay, very easy, right? So you do your analysis, you know what the issue is. Should use of force have been used? Well, we looked at the three factors. No, obviously not. Pretty easy. Now, very narrow, okay, because we know that there's a lot of other words on that paragraph, on that page. We just looked at the 3 bullet points. What did the paragraph before that say? What did the paragraph after that say? How about the page before that or the page after that? They just pulled out 3 factors, did a brief analysis on it, and came to a conclusion based on the rules. But what if the rules aren't exactly right? Then your application of the rules to the facts are going to lead to a bad conclusion, which is exactly what Mr. Nelson is talking about. So you're going to see here, what does he do? What's his defense? And he just reads the rest of the document. He just goes and reads the rest of it, provides some context, and he's expanding the scope of the analysis. So here he is in court this afternoon.
So again, you've reviewed the Minneapolis Police Department policy that incorporates Graham versus Connor, correct?
Correct.
And within the Minneapolis Police Department policy, I'd ask the court to, I would like you to publish Exhibit 106. I have 106. There is, at Exhibit 106, there is the incorporation of Graham versus Connor.
Yes.
All right. Now, the authorized use of force in the state of Minnesota exists primarily from a state statute, correct?
Yes.
And then that state statute, in terms of the police department policy, has to be consistent with the Graham versus Connor factors, right?
Correct.
And it's fair to say that there's more to the analysis of Graham versus Connor than simply the severity of the crime, the immediacy of the threat, or the act of resistance, right?
Yes.
In fact, what the ultimate police department policy says here is because the test of reasonableness under the Fourth Amendment is not capable of precise definition or mechanical application, its proper application requires careful attention to the facts and circumstances of each particular case, including those 3 factors.
Correct.
Right? Not limited to those 3 factors.
Correct.
After the policy discusses those 3 factors, the policy goes on to read that the reasonableness of a particular use of force must be judged from the perspective of the reasonable officer, correct?
Correct.
On the scene, correct?
Correct.
Rather than with the 20/20 vision of hindsight, right?
Right.
And the reason that becomes important is this next paragraph, which reads, the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Agreed? That's what it says.
Yes, you're correct.
And this is the Minneapolis Police Department policy.
Correct.
And then it concludes by saying that the authorized use of force requires careful attention to the facts and circumstances of each case. Agreed?
Correct.
All right. So ultimately, the analysis of the objective reasonableness of any case has to be a consideration of all of these thoughts that are contained within the policy.
If they apply, yes.
And this is not an exclusive list of factors that apply, right?
Correct.
Because ultimately, it's what's called the totality of the circumstances
Yes.
event, right?
Yes.
So we have to look at the entirety of everything that's going on, right?
Yes, we have to look at the subject's actions as well as the officer's actions. And typically during my analysis, I look at the actions before, during, and after, what the officer knew at the time, and things of that nature.
All right. So this is such an interesting thing that's happening right now. I can't even explain it, but this is the police department's policy working against the government right now, which is such an interesting thing. So yes, the way that the analysis was done by this witness makes sense if you want to be very narrow and reach a particular conclusion. But that's not how the police write their policies. They don't want that to happen because typically these are being used against the police department. These are being used against the department, generally speaking, right? This is a police department policy. So they want to write them in a way that their institution is somewhat protected. And so, yes, they're going to give us 3 factors that you should analyze, but they're going to give us a bunch of escape routes, right? We just heard Mr. Nelson go through all of them. He talked about reasonableness and about other factors, and it's the totality of the circumstances analysis, which encompasses anything and everything. And we have to deal with this a lot as criminal defense attorneys. We say, yeah, but judge, he lied about that, and he lied about that, and he lied about that. So there's no way that he can make a reasonable observation that our client did what he claims they did. And they just come in, the cop says, well, no, I mean, technically I didn't have that or that or that. But based on the totality of the circumstances, suddenly I think that I was justified. I had enough probable cause to do whatever, nonsense I just did. And the judges just go, yeah, that sounds good. Totality of the circumstances, pretty reasonable expectation. That sounds fine. So you get to do whatever the hell you want. And so the police department policies are written in that way. They're written to give them a bunch of escape hatches and pressure relief valves so that if they are in a situation like this, in this case, Derek Chauvin was a former cop and he's on the outs, but the same policies that protect the police, generally speaking, are still going to protect him because they're written with all these holes in it. It's not as as black and white as this is. It's not as cut and dry. The prosecution wants to make you think that, but these are written specifically to not be that way. So that when somebody shoots Breonna Taylor, when some maniac cop is firing his gun just through apartment buildings, that he gets off. He doesn't get charged with anything for that. Grand jury, indictment, the whole thing. Oh, no charges. Why? Because he had escape hatches. Now, he was still on the inside of the blue shield of silence, inside the blue code. So he was still within that energy shield that protects him against any criminal liability. Derek Chauvin got thrown outside of that bubble, and so now he is no longer technically protected by the government bureaucracy. But he still was operating under the same set of policies and guidelines, which are written to be so one-sided, they're virtually impossible to breach because they have all of these escape hatches. Well, hindsight is 20/20, and we got to trust the officers who were on the scene. Objectively reasonable, what's that standard? We should, yes, hold to that standard, but take in all of these other factors. And so you can just sort of craft whatever you want. The policies are designed this way. So what the prosecutor's trying to do is really narrow that in, and Mr. Nelson is blowing it up. Oh, well, all right. Well, here's an escape hatch that you idiots put in your own policy. So we're going to use that, and we're going to use that one, and we're going to use that one. And this is just standard. This is just how it works. So they're using their own policies against them by reading from the document. This wasn't anything that Eric Nelson or Chauvin had to create or go get somebody to twist the words on. And I didn't mention this, but before this happened, Eric Nelson was going to go in and ask that witness about the Supreme Court case specifically, and there was an objection, and the judge kind of called him off to the side. They had a sidebar, and he came back and he changed his questioning just slightly. So he didn't go into the case law. He just read the rest of the document because the case law may have been outside the scope of the direct examination, so he may not have been allowed to ask about that. He didn't need to. He didn't need to go in and cite all of these different Supreme Court cases. All he needed to do was just read the rest of the police report, which gives them all of the escape hatches, all of the leverage, all of the ability to maneuver. He just reads it right back to him. This is your own policy. It's talking about all these things that it says I can do, in fact. And he gets his own witness to go, yeah, all of the different totality of the circumstances. He finished his sentence. He finished Eric Nelson's sentence. He said it's really not just about three factors, right? It's more about the totality of the circumstances. Because he knows. So, not a good day. Not a good strategy there, in my opinion. Now, this was also a interesting segment of the trial because during his questioning, Mr. Nelson, Eric Nelson, the defense lawyer, is also asking him specifically about something that George Floyd said in the clip itself. Because he's reviewing a lot of the body cameras. He's reviewing the use of force. And he plays this clip, and the prosecutor doesn't object, and there's no conversation about this. Eric Nelson is saying that George Floyd said, well, let's see, if you haven't heard it yet, let's see what you think about this. Here it is.
I'd like to publish part of the body-worn camera. It's Officer King's body-worn camera, starting at 2021-01.
This is a portion of what's already been received.
Yes.
Any objection?
No objection. I'd like you to see if you can tell me what Mr. Floyd says in this instance.
Ask yourself, what does he say?
I didn't Mercedes. Believe. I didn't Mercedes. Believe.
Hear what he said?
No, I couldn't make it out.
Does it sound like he says, I ate too many drugs? Listen again.
I didn't Mercedes. Believe.
I can't make that out, no.
So in the chaos of a situation, things can be missed, right?
Yes.
Let that hang out there. Did he say ate too many drugs? Ate too many drugs. Did he say that? Well, or did he say something like, I ain't do any drugs? This is like Yanni versus Laurel. I ate too many drugs. I ain't do any drugs. What do you think? So here is what I have done. I have taken that clip, just that clip. I have it played at regular speed like we heard it in court today. I have it slowed down by 50%. Then I have it sped back up again. So I'm going to play it right now. I'm going to turn the volume up just a little bit. Ask yourself, what does he say? Does he say, I ate too many drugs? Or, I ain't do any drugs? Pretty close. Let's take a listen in and you be the judge.
I ain't even Mercedes. Please. I ain't even Mercedes. Please.
Here, slow.
I ain't even Mercedes. Please. I ain't even Mercedes. Please.
That's a tough one. We're going to have to see what people say in the comments, I suppose. So get those queued up there. Ate too many drugs or ain't do any drugs? I don't know. It's a good one. Well, next up, we've got this guy, James Reyerson. He is with the Bureau of Criminal Apprehension, and he was the next witness who came out today. So we have the ain't do any drugs thing. Now we get an answer from him, actually. So he listens to the same clip, and we're going to see what he has to say about it. But he is somebody with the Bureau of Criminal Apprehension. He had a lot of testimony today. I'm going to read a synopsis from him because we got just so much more to get to. He's a senior agent from the Bureau of Criminal Apprehension. Testified on Wednesday that Derek Chauvin kept his weight on a handcuffed Floyd for minutes longer after Floyd was no longer talking or moving, which we already knew, right? They're showing us stuff we've already known. Having earlier reviewed various video sources regarding the encounter, he said that Chauvin's knee went on the back of his neck after 8:19 p.m. He felt silent after 8:24 p.m. And he says, does it appear that Officer Chauvin is using his weight to hold Floyd down? The special agent says, yes, it does. All obvious stuff. We don't need to spend much time on it. He said that the weight was still on Floyd for 2.5 minutes later after when paramedics arrived before the midday break. He says they met in Minneapolis, with one of them going to the scene. He went to the city hall. He took a full body photograph of Chauvin, which I'm going to show you in the next slide, which was shown to the jury. Matthew Frank asked how much the officer weighs, and so Chauvin is $140. He then added that Chauvin's duty belt and his gun would add another 30 to 40 pounds to it. The prosecution spent a fair amount of time talking about the knee, talking about the pressure, and we talked about this yesterday about the kneecap and about sort of adjusting your body weight so that you can pinpoint some of that, right? You do some of this in martial arts with your elbows and your knees and your shoulders. And it's something that they're spending a lot of time on today. We already know that, so it wasn't that interesting to me. But this is the image that they took of Chauvin right after the incident. And you can see, right, he's got some body armor on. He's got a belt on. He's got a gun. He's got, all of the fittings, handcuffs, and so on. And so, yeah, maybe he does have an extra 30 to 40 pounds on his body. And so, yes, that is an individual that would be 140 pounds plus 30 to 40 pounds, 170, 180 pounds, which is... It is what it is, right? And so not much really interesting testimony there. Then we change gears and we meet Mackenzie Anderson. That's this woman here. She is also with the Bureau of Criminal Apprehension, and she is a forensic scientist. She is somebody who does the processing of the vehicle. And so she gave us a little bit of a tour around the vehicles today. So she specifically, we started by going into George Floyd's vehicle, and you'll notice that this was Exhibit 142. Let me move myself over here. These are marked on the bottom, so I'll move myself up to the top. But Exhibit 142, we'll notice that there is a packet of Airheads over here, which are delicious. But we also have a pill right here in this little area of the dashboard. So this was within Floyd's vehicle, and this is Exhibit 142. Then we have another angle here, and you're going to notice that this is the prosecutor's line of questioning. So this is the government asking her these questions. So she is the person who processed the vehicle. So everything gets impounded, gets transferred over to her. Obviously, somebody has to be in receipt of that. They got to go through the vehicle, make sure everything is properly cataloged and organized, pictures are taken so that the evidence is preserved. Then what they do is they actually seal the vehicle up, and they put crime tape on it. And so sort of like, you know, when you order DoorDash now in the era of COVID, everything's kind of sealed up and you go, hey, this was packed by whatever, and you break the seal. Hey, so that way I know that the driver has not gotten into my food. And same thing here. They're sealing up the vehicle in a way that they say, we know that this is being protected, that people are not just opening and coming in and out of here. And so they have to catalog it, seal it up, and just preserve it until the case is resolved. So this is the prosecutor who's asking these questions and walking us through this. And this is not good information for the prosecution, in my opinion, but you're going to see how they are trying to fix it a little bit. And we already saw some of this previously. So let's continue to go through some of this imagery. So here is I think this is evidence number 48 or 46 we have. And so the prosecutor, once again, is walking us through this, and we zoom in and you're going to notice that they call this out. This is a Suboxone Packet, which is a prescription drug that people will take when they are addicted to opiates. We already knew that. We already knew that George Floyd had an opioid problem. We already knew that his girlfriend also had an opioid problem, and that they had sought treatment on a number of different occasions. We also know that they were buying drugs or had previously bought drugs. We don't know about that particular day, but we know previously that they had from Maurice Hall because of the fact that, well, he was in the video that we all saw, but he was also somebody who has very recently invoked his Fifth Amendment right. He does not want to be incriminated by testifying, which is good advice. But other people have implicated him, and Floyd's girlfriend herself said that they bought drugs from him previously. So they're on Suboxone, and we know that the government has to deal with this really bad fact that Floyd had 11 nanograms per milliliter of fentanyl in his blood, along with methamphetamines and other substances. So how do they deal with that? We've already seen how they're going to deal with it. They're framing Floyd as a recovering addict, which is the right theme for, I think, this area of the trial, right? This was somebody, yes, we know he was an addict. Addicts don't deserve to be murdered. Just because he had an opioid problem or a fentanyl problem doesn't mean that he's a bad person who deserved to be executed by a police officer, is their argument. So they're sort of embracing that bad fact. Oh yeah, we know they're drugs. We know that this is all coming out. In fact, we're going to show it to you. We're going to show you around the vehicle, and we're going to show you the fact that he's trying to recover from the drugs. As you can see, here's Suboxone. It's right there, along with some lemon heads, which are a less favored candy. But we have that in picture 46 and 47. We've got over here Suboxone again, right? These are prescription drugs. They're for people who are trying to get off, to sort of wean off of the opioids. It helps taper down some of the cravings on the way out. And so they're just walking us around. And next up, we get this image. So this is evidence marked number 48. And we can see here 2 pills, in fact, 1 and 2. And so they put them together. Here's a different angle. So you can see both those there. They look like homemade pressed pills to me. You look like this. I mean, honestly, this looks like some, even potentially like marijuana residue if you just look at it, but you know, who knows what that is. But this definitely, they look like homemade pressed pills. You can see sort of the irregularities there on the pill itself. Doesn't look like, you know, something pressed professionally. And this is part of Floyd's vehicle. So we're going to get into that because we have 2 forensic forensic scientists who are going to testify about the testing that they did on those pills and what their conclusion are. But before we get there, this same witness takes us over to the police vehicle. So now, remember, George Floyd, this is where this all started, in this vehicle. But then they pulled him out. They tried to put him in the back of the police vehicle, and she's responsible for the same thing there. She's responsible for inventorying the vehicle and making sure that everything is properly documented and cataloged. So she takes us around the vehicle, and here is a picture of the inside of the back of the squad car, and we can see a shoe here, and we can see a harness over here. And so this is one of the first pictures that she took, but they eventually move stuff out of the way. And then we see something that looks like this. So here now, she marked on the vehicle with these different stickers areas where there was blood or it looks like some bodily fluids. And we also will notice that once the shoe was moved out of the way, we see another pill there. Okay, that's a whole nother pill. And so the theory is this pill is either magical or it entered the back of this vehicle from Floyd's vehicle because Floyd was the person who brought it in. Otherwise, where did it come from? Right. And she goes through and she tells us specifically more about some of her testing, and then she gives us some conclusions on this. And here she is in court testifying this afternoon.
Now the strap has been removed and we see some other items here, correct?
Correct. This was after the strap was removed, and this denotes the 4 locations on the rear passenger seat bottom where blood was indicated, and I collected samples from each of those 4 areas.
So as we've seen then, there were, in my calculation, 7 different blood-like stains, 6 of which presumptively tested positive as blood, correct?
There were 7 that presumptively tested positive for blood and 1 additional, so for a total of 8.
8.
Okay, so that was just a clip of her testimony. But basically she goes on and she continues to say, yep, those came from Floyd. Saliva on the pill came from Floyd. And so essentially you can go look it up on the Star Tribune, but they're reporting that, yeah, I mean, it's looking like the DNA evidence shows that the blood in the back of the vehicle and the pill itself had Floyd's saliva and DNA on it, which explains how that pill got there. And that is not a good fact for the government. Right, especially if if the defense is going to come out and be saying that this was a last-minute ingestion type of situation. And they've got priors on that. They've got the 2019 case where something very similar to that happened. So this, now they have to deal with this. The government has to deal with this. This is not a good fact for them, but they have to call it out. If they didn't bring this to the jury's attention and Eric Nelson, the defense, brought it to their attention, they would look like liars and cheaters. And they would look like they're trying to manipulate the jury. So they can't keep that stuff out. They got to talk about this stuff. It's very bad facts. But how are they going to try to now fix this? Well, let's talk about the analysis of it. So what if there's a pill? So what? What's in it? That's where we get to our next witness, who is Brianna Giles. This woman here, she's a toxicologist, and so she is a forensic chemist. I actually don't know if her official title is a toxicologist, but she's a chemist. She works probably at the forensics toxicology department, whatever crime lab she's a part of, and they do analysis on bodily samples, bodily fluids, and other types of evidence. And so what she did is she tested the pipe, one of the pipes that they received, and what did she find in there? It was marijuana. There was THC in there. There was no evidence of the marijuana, no evidence of the actual green leaf, but there was remnants and residue of THC, which means it was a drug pipe. And so that's kind of how her testimony started. But then she walks us through the analysis of the pills. And so the way that this worked is the prior witness was the person who received the vehicle, did the inventory, did the photographing, the cataloging of the evidence. She seals that sucker up, impounds all of the pills, impounds the evidence, transfers it over to this gal. This gal, Ms. Brianna Giles, then is the chemist who does the analysis. And she works for the government. So we're going to hear from her. Then we're going to hear from a private chemist who also does her own analysis on it. So we've got corroborating reports. So let's take a look at Ms. Giles and see what she can tell us about the testing procedure and the pills.
They're actually...
Sorry. Don't know. All right.
First type of testing.
There are actually 2 pills in item 48?
Yes.
And did you test them at separate times?
Yes.
Okay. When you initially tested them, can you describe for the jurors the condition of item 48, or at least one of the pills? Well, let me ask you this way. Did the 2 pills look consistent with one another?
Yes.
And so can you describe for the jurors the appearance of the pill when you saw it?
Both pills appeared the same, both white and round with markings, RP on one side and 10/325 on the other side.
And you mentioned earlier pharmaceutical markings. What did you mean by that?
The markings RP 10325, they had a mark or a logo on both sides of the tablet.
Now, in your job, do you have to become familiar with how manufacturers mark their pills?
Somewhat, yes.
And when you saw these markings, did you recognize them as anything?
I did not.
So they're just markings on those pills?
Yes.
And so it's not like you recognize these as markings for aspirin or something of that nature?
Correct.
And so initially you only tested one of the pills. Why was that?
Per our policy at BCA, typically when we receive multiple tablets in a submission, we only will analyze one of that population if they're all similar, unless it is requested that additional tablets are analyzed.
And did that in fact happen here?
Yes.
Who requested that? Do you remember who requested that you test both pills?
Agent Reyerson.
All right, so we've got a basic overview on the testing process, what she did. It sounds like these had some numbering, some labeling on them, some markings on them. So she guided us through the process, pretty standard stuff. Now, here is what she concludes.
First type of testing is looking up the markings, and upon looking up the markings in the database, the markings did indicate the material contained oxycodone and acetaminophen. I followed that up by scraping off a portion of the tablets and putting it into a liquid, and that liquid is then injected onto a gas chromatograph mass spectrometer, or GCMS.
Now, you indicated that the markings on the pills indicated, I'm going to butcher it if I try it, but that they contained what?
Oxycodone and acetaminophen.
In your experience and your training in this field, do you know whether sometimes homemade pills are given those same markings to make them look legitimate?
Yes.
That can happen?
Yes.
And so in this case, you got that initial indication from the markings, but you proceeded to follow through with the testing, correct?
Yes.
And you tested both of those pills, correct?
Yes.
And did you follow all the standard procedures you need to do when performing that kind of testing for your laboratory?
Yes.
And what were the results of the testing?
The tablets contained methamphetamine and fentanyl.
And are you able at the BCA lab to quantify how much methamphetamine or fentanyl are in those pills?
For methamphetamine, yes. For fentanyl, no.
All right, so very, very interesting testimony from her, right? Coming out and owning it. What were in the pills? Methamphetamine, fentanyl. Can you quantify them? The meth, yep. Fentanyl, no. So we know that now. Jury knows that now. And the question that I have is, does that matter? I think the answer is a resounding yes. The question is, how much does it matter? From my perspective on this in the world, fentanyl is a highly, highly dangerous molecule, and it feels to me like most people know that. We hear stories on a regular basis of dozens of people just dropping dead around the country, and it's pretty indiscriminate. It's anybody who, you can be a high school, college kid, 50, 60-year-old people dropping dead from fentanyl. And it feels like most of the zeitgeist of our country sort of recognizes that. Everybody's sort of in touch with this, that fentanyl is a very dangerous molecule, stay away from it, and that even a little bit can kill you. And this is why people are dropping dead. They think that they're getting something that has been laced with some fentanyl, even a tiny little bit. You see some of those images and the memes going around, the public service announcements. You have a penny and you have just like 3 little specks of fentanyl, and they're like, hey, this amount of fentanyl will kill you. So if we're even talking about the F word here at all, and somebody's dead, it's pretty easy, I think, to connect the chain there, to connect those dots. So she just come out and told the jurors that 2 pills were right there, meth and fentanyl, and they were fake pills, right? They were trying to pass themselves off as aspirin and oxys, but they weren't. There was something much more serious. And what she's talking about here is that you really can't, well, in the next clip. So, all right, in this clip, she just finished and she said, we can quantify the amount of meth, but we can't quantify the amount of fentanyl. So she's talking about sort of two different problems, or 2 different analyses that are happening. So she uses the same methodology that we use for DUIs and other drug cases. It's called GCMS, gas chromatography mass spectrometry, and it's a highly technical testing method that will quantify how much of something is in something. So the example would be in a DUI case. They test your blood, how much alcohol is in the blood. Okay, we know there's alcohol in there, but we don't know how much of it is in there. So 2 different things. One is the quality, or a qualitative test. What's in there? What's going on with that? The next is quantitative. What is the amount of that? So yes, we know that there was alcohol in your blood, but how much of it? That's where we do the GCMS testing, and that gives us the quantification amount. Here, what she's saying is we can quantify the methamphetamines, but we cannot quantify the fentanyls. And you're going to see that carry over into this line of questioning with Eric Nelson. So very short cross-examination from him today on her. And he says specifically, can you say it's fentanyl? She says, I basically can't confirm. I can't confirm or deny it. I can't say that it is, and I can't say that it isn't. Here is Eric Nelson today.
just to be clear, item 48 came from the center console of the Mercedes-Benz, or were identified as coming from the center console of the Mercedes-Benz, correct?
To my knowledge, yes.
And that's what was reported to you?
Yes.
And the other items, 51, 52, 53, and 54, they came from the backseat, or they were identified as coming from the backseat of Squad 320, correct?
I can't speak to 54,
But
but
51,
51, 52, and 53, yes.
they were identified coming from the backseat of Squad 320.
Yes.
And in terms of is it fair to say that there was some evidence that didn't meet your laboratory scientific threshold or scientific standards that a different controlled substance was potentially present?
There were indications of other substances. I can't speak to whether they are controlled or not controlled substances.
Okay. And those were brought to the attention of everybody involved, right?
For business purposes, it is in my notes.
Okay. And that was fentanyl
I can't confirm.
because it simply didn't meet that laboratory requirement
Yes.
in terms of quantity, right?
The testing I did not have any type of quantitative measurement.
But in terms of whatever other markings you may be looking for, right? Whatever guidelines. You can't say it was or wasn't fentanyl.
Yes.
I have nothing further.
Go ahead. Thank you. Sit down.
Okay, so I think what's happening here, and they're not getting too technical here for good reason, because the jury's eyes would glaze over. But they're having a conversation about the difference between sort of qualitative and quantitative. So she's being coy about this, and I think she probably knows that it's fentanyl, but she can't say that because scientifically you can't prove it based on the test that she did. And so, you know, they typically will do this. You know, let's say somebody gets arrested for a DUI and they don't really know what that person is on. They give them a breath test. It's not alcohol, but they know that person is impaired, but they got to dig in a little bit further, and they can't identify what it is. Is it cocaine? Is it methamphetamines? Is it fentanyl? Is it any other opioids, prescription drugs, anything, right? There's a whole cocktail of drugs that it could be, and it may not even be one of them. It may be a handful of other things kind of mashed in there together. And so what they'll typically do is they'll do sort of an initial screen, and they'll say, well, look, we know that these drugs have certain properties, and so if we chemically test them doing a certain baseline test, then that's going to give us an indication of what it could be, right? This is in the opioid class of drugs. I don't know specifically which one, but it's in that general category. It's like, I want a soda. What kind of soda? I'll have a Coca-Cola. Well, not anymore, but I'll have a Dr. Pepper these days, right? So it's a broad identification of it. And so she can't come out and say it's fentanyl, because it could be fentanyl, but it could be a number of different things. So she can't conclude that it is, but they know it's in there. The reason she can't quantify it is because they didn't do what sounds like the quantitative test. So she can't say how much of that thing that we think is in there is actually in there. So it's a lot of science, sort of techno mumbo jumbo, but that's what's going on. So they bring in this next expert witness who then does come in, and she's able to quantify it a little bit more. Now, this is somebody with a private lab. The reason why the government is not willing to come in and testify about any of this is because if she's on record saying, sort of unwinding how the crime lab meets their thresholds and what some of the quantification and how all of that works, and then she might be held to that in future cases down the line. So she's just going to say, listen, we set a baseline threshold. This does not meet that threshold. Therefore, I can't talk about it. Right. And so like if this were, well, anyway, let me leave it at that. So she is sort of speaking as a government official and being coy about what she can testify about because she's a government person, and they don't want to open her up and expose her to cross-examination from defense attorneys throughout the rest of the state. Right. If she gets into that a little bit and breaks that down, how all this works and how they quantify it, then that may damage her credibility moving forward. Right. What if she's called in as an expert witness on other DUI cases and it involves fentanyl, and she comes back in and she just got beat up by a defense attorney talking about how they quantify and qualify certain drugs. So she's just done. I don't want to talk about it. So they bring in somebody else to talk about it. And this is this woman now. So Susan Nee, she's also a forensic chemist, but she is with a private company. So they bring her in. Testimony's pretty quick. And this is her ultimate conclusion. So she's going to give us some information about the quantities of the drugs that are in those pills. And she's going to give us some relative comparison about those drugs and how they relate to some of the other cases that she sees. So this is Susan Nee. She's a forensic chemist from a private company. Oh, wait, I have this somewhere. Let's see if I can find this clip. I clipped it. I probably did not export it. Ugh. I was skidding in here. We're going to save that for tomorrow, but basically what she does is she comes back out and says that they're pretty low levels. So I think the takeaway, if I remember correctly, is she says it's less than 1% of fentanyl in the pills. But that's actually normal, right? It shouldn't be like 80 to 90% in a pill. She says it's like 1%, but that's normal because it doesn't take much fentanyl. Most of the other stuff is filler stuff. As to methamphetamine, she says that those levels are in fact low. They're much lower than normal. So if you had to guess on this, there's more fentanyl in these pills than there are, or I wouldn't even say it that way, right? So this is very, very tricky language that they're using. So she's talking about percentages and relative concentrations across cases that she's seen, and Mr. Nelson doesn't even cross-examine her. So she's done. We're not going to hear from her tomorrow. Very brief statement. I did clip it. I don't know why it's not on my slides, but I'll figure that out tomorrow. But that was the conclusion of Derek Chauvin's trial today. So we're going to hear, of course, different interpretations of expert witnesses from the defense. They're going to bring in their own forensic people to come in and talk about all this stuff. Okay, so you also tested that. What is your analysis? What is your conclusion? And then the jury is going to be able to listen to it. They're the ultimate fact finders, and they're going to decide how to interpret that data and how to render a verdict. So we're going to stick with Derek Chauvin until we reach a conclusion. So we'll be back here tomorrow with more of those updates. And so let's take a look at some questions over from watchingthewatchers.locals.com. And for some reason, our slides are just not syncing up. So I am having to take a quick minute and go over to Miss Faith and her slides and see what's going on. We have Lassie91. So these questions come over from locals.com. Watchingthewatchers.locals.com is where you can ask these questions. And this is from Lassie91. It says, I found the use of force witness from LA to be more argumentative than Genevieve Hansen. Why didn't the judge ask him to cooperate or call him out? It seemed like he answered every question yes, it can, to qualify it. Are there any special rules for expert witnesses? If I was on the jury, this would have annoyed me. That's an interesting perspective there, Lassie. I didn't get that same feel from him, and I watched a lot of his testimony. I didn't get that argumentative feel from him, which is why the judge probably didn't scold him. I mean, I think he was answering questions. Yes, it can. Yes, you sort of just disregard all of the rest of that. Yes, but no, we don't care about that. Yes or no? Yes? Okay, fine. You can explain it. I'm not asking you about that. Yes or no? Right? And that's why what Nelson is doing with him are called leading questions. And so he's allowed to do that. And if you have somebody who's trying to qualify everything, you just say, okay, so it can happen. Great. Next question. Oh, that also can happen. Perfect. Right. And so I think that is what Nelson was doing. But, you bring up an interesting point. The jury's level of annoyance and whether they get tired of hearing the same thing over and over and seeing the same thing over and over, which we have seen a lot of, quite frankly, right? We've seen a lot of the knee, the weight, the pressure, a lot of the emotional stuff. At some point, we're in 2 weeks now. At some point, they're going to be asking themselves, all right, what about the blood results? What about some medical testimony about what actually killed him? And we're getting close to that, but at some point, you got to think about that. Is this becoming too duplicative? Not legally, but just because the jury doesn't want to hear about this anymore, right? They're tired of seeing a man die on video over and over and over again. That can be very grating on anybody. We have Ma Fox says, long question from Ma Fox says, I have a feeling this will come up tonight. Do you not think it's objectively unreasonable to suggest because a crowd is screaming at you to render aid, that rendering aid would somehow increase the likelihood of violence ensuing? Rather than continuing to sit on top of what appears to be a deceased person and is in fact, as per medical expert testimony, is a deceased person, which is more likely to inflame tensions. The idea the defense has that it's unreasonable to provide aid to Floyd because the crowd was screaming to provide aid and was somehow a large enough threat to warrant doing the complete opposite seems extremely unreasonable to me. Objectively unreasonable even. Ridiculous, you might say. Ridiculous, you might say. I think that this is Mr. Nelson's weakest defense for Mr. Chauvin. Your thoughts? It's a good question. I think you're onto something. So I think you're kind of talking, this is I think a matter of interpretation and perspective. It's a great question. And I actually don't disagree with you. I think that anybody who is a regular lay person, anybody who's a juror is going to want to know why they were on his neck for 9 minutes. Why didn't they help him? There were a lot of other people out there who could obviously clearly see that what was happening was not right. they had the wherewithal to even shout at the cops and say, hey, what the heck are you guys doing? Get off of him. You're killing him. He's dying right in front of you, right? We all saw the video. Why didn't they render aid? There needs to be an explanation for that. I do not disagree with you at all. I think that that absolutely has to happen. And I think that might be part of the reason why Chauvin testifies. If that happens, which he probably still won't. We'll see. But it is important that people from a humanitarian perspective understand that. I think that the way that the defense explains that is by prioritizing, right? They have the decision model, the decision matrix, and they're just going to say that they have to prioritize certain things. And in this case, they felt threatened there at the time. All of these other officers after the fact can come in and say, no, it wasn't reasonable. Or Jody Stiger can come in and say, no, I mean, people shouting at you or calling your names isn't enough to warrant not rendering aid. But they weren't there. And the manual itself, as we heard today from Mr. Nelson, says you got to consider the officers who were there at the scene. And so there were 4 of them who all made a similar judgment, right? Not one of them rendered aid. Why not? Maybe because they all felt like the situation was overbearing on them and that their safety and the safety of their fellow officers was at risk. So they maintain the scene. They prioritize their safety over Floyd's safety, and they wait for the medical people to get there. The medical people get there. Guess what? They don't render aid either. They say, this is dangerous. We got to move out of here. They pick him up. They load him into the back of the vehicle. They move around to a different location, as was heard by the medical examiner's own testimony. And they say, at that point, that's when we started the chest compressions. They hook him up to the machine, and the machine starts trying to bring him back. So even they didn't feel safe on the side of the road. So yes, I think that it is a very important thing from a humanitarian perspective that people answer that question, that the jurors understand this. And Nelson hasn't presented his case yet. He hasn't presented any justification for it. So it is perfectly reasonable, Ma, that you think that it is a weak part of the case. I think that, let me make sure I answered your question. Do you not think it's objectively unreasonable to suggest because a crowd is screaming at you to render aid, that rendering aid would somehow increase the likelihood of violence ensuing? I do not think that that is objectively unreasonable thought. I think that it could be reasonable to decide not to render aid, to protect yourself until the situation has dispersed. Okay? He's a police officer, so his priority is to preserve his life, his officer's life, and do his job. Genevieve, who's the firefighter, she saves lives. Okay? So that's her high priority, but not the officers. So we have a different perspective on priorities, and Nelson and Chauvin are going to have to explain that to the jurors. We got Deep State in the House, says, do you think it was a mistake in strategy by the defense not to emphasize that Floyd apparently had a mouthful of pills as he was being arrested? Do you think it was a mistake by the prosecution to lay out those facts around the drug use in such a naked fashion disconnected from their prosecution theory? So, number one, no, I do not think it was a mistake by the defense to not emphasize that he had a mouthful of pills as he was being arrested, because they have not gone yet, right? They're up next. They're coming, and that will, I would venture to guess, is going to be a big part of their theme moving forward. And do you think it was a mistake by the prosecution to lay out those facts? No, I don't. I think that they have to do this. It's called drawing the sting, right? We talked about this in a prior episode, but you have to come out with your bad facts and communicate those to the jurors, because if they come out and you didn't tell them about it, your credibility goes right out the window. They're going to think you're a liar and a manipulator and a cheater. So they're coming out regardless. Better to announce it yourself than allow somebody else to do it. Red Dragonfly says, with the crowd didn't have another option, handcuffed 3 grown men could not get him into the back of a patrol car. They were in the middle of the street and the sidewalk was covered with an angry idiots, didn't have any options, at least not good ones. Yeah, that's another perspective. And that's going to be their perspective, right? They're going to say, we couldn't do anything. In fact, 4 of us agreed. We waited. Medical people showed up. They agreed that we couldn't do anything. That's why they loaded him up and moved him around the corner before they started to administer aid. LT13, why are they not bringing up that they were trying to please him by doing what he requested? Let me lay down. Only way with cuffs on, which were already there, would be prone. It's all coming out like they fight him to the ground. Yeah, I mean, it's because it looks like a fight, right? It wasn't a conversation. I understand your perspective, LT13, but it wasn't like hey, George, what can we do to accommodate you? Well, I'd like to lay down. Perfect. Put the handcuffs on and we'll just lay you down here, right? It was a very tense altercation that resulted in him sort of kicking himself out of the other end of the car. They walked him around on the sidewalk side, put him in. He kind of flapped out of the other side before he was, he wasn't like gently laid down. He was laid down, right? He was on the ground. And so I understand your point. And it's not a bad point, right? Floyd was saying, let me lay down. Don't put me in the car. Don't, I can't breathe, doing all these things. And they kind of accommodated, right? Okay, here's on the ground, lay down. We're going to hang out here until medical shows up. And he died right in front of them. I understand your point, but I think the way that it actually unfolded was not the same tone. We have Ma Fox says, I believe a common comment you'll get in the future is that the witnesses seem to be contradicting themselves in testimony depending on who asks the question. The prosecutor's defense asked very specific questions that lack context much of the time, so don't lend it too much credence, in my humble opinion. Yes. So that's kind of the point, right? When you're doing cross-examinations, you're trying to get that person to contradict themselves. That's almost the entire point of cross-examination. And we saw that today with Jody Stiger. Comes out, these three factors show conclusively that use of force was unreasonable. Nelson comes back out and says, yeah, but aren't you supposed to take in the totality of the circumstances, including the officer who was there, including these other standards that you kind of failed to mention when the prosecutor was asking you about them? He read the rest of the document. So it sounds contradictory. It kind of is, it kind of isn't. And so ultimately, the jury has to weigh out these facts, but it's a complicated thing. And you'll notice, you got to be very careful with words too. They'll ask a question and somebody will sort of, couch it, or they will modify it. They'll put some conditionals on it in order to make it less impactful. So we're going to see a lot of contradictions. That's what's so fun about a trial. We have Patriot Must says, wouldn't a good counter argument for the defense be to ask what would be appropriate action in that situation if they are disagreeing with the amount of force? Well, yeah, I was thinking about this earlier today. Yeah, we're talking a lot about use of force, and they're very unhappy with a knee on the neck, but only in this case, right? Other cases, we see cops get away with everything all the time. Breonna Taylor's cops got away with shooting her. We saw Daniel Prude's cops got away with murdering that man, which was about as bad as the George Floyd case, if not significantly worse, and happens all the time, right? Cops kill people all over the place. So what if Derek Chauvin had shot George Floyd? Would this have happened? What if he said, listen, I felt scared when he was kicking out the other end. I thought he was coming after me. I thought his hands were free, or, I don't even put the handcuffs on him. Just wait for a defendant to go bananas and then just shoot him rather than trying to detain them, put them in handcuffs, wait for EMTs, all that stuff. Just shoot them. Because cops get away with that every day, all over the country. People get shot. No ramifications for that. But if you pull somebody out the back and you put their knee on the neck, that somehow becomes murder. So, and I'm not advocating that, right? I don't want cops to shoot people. I'm not saying that George Floyd should have been shot. But I'm saying that if we're going to have different conversations about the use of force and standards, we have massively different standards in this country. We see cops all over the place who never get charged with crimes for killing people in much more egregious situations than this one. So I'm not real sure, again, these cops can come in and just navigate through their policies to come to any conclusion that they want. In this case, Derek Chauvin is a disfavored person. He's outside of the blue shield. But if they had decided we're going to keep him inside our little ecosystem, they could manipulate these policies all day to make sure that he doesn't get convicted. It happens regularly. Probably would have never even gotten indicted. Breonna Taylor's people didn't get indicted. Prude's people didn't get indicted. And the list goes on and on and on. Even when you go to trial, we had the Daniel Brailsford case here. That cop got off scot-free, not guilty, for executing a man with a gun in the middle of a hotel room. Ridiculous. All right, so next up, let's see what we've got. Osak says, hey, Rob, big fan. So do you think a reason for so many prosecutors could be that if the prosecution loses the case, the blame won't fall on just one or two people? That's a good idea, right? Sort of to distribute the blame for that. It's not a bad thought. Ma Fox says, one of the cops asked him, what are you on, man? I believe it was Chauvin. I'm presuming that was said just after Chauvin asked that. Context is very important. Yeah. And I think there was some conversation about hooping and all sorts of stuff. And all of this is going to come out when the defense presents their case. Sasha Sisha's back in the house. Haven't seen you in a long time. Welcome back. Hope you're all doing well on this beautiful Wednesday. It's finally warm here at snowy Buffalo. In my opinion, people might hear different things based on their bias level because most people only hear what they want to hear. If you think Chauvin's guilty, you want to hear I ate too many drugs. If you want him not guilty, you want to hear otherwise. Maybe I can be part of the Mindhunter series. Haha, as usual, love your show, Rob. Thanks, Sasha Sisha. Appreciate you being here. Yeah, it's like Laurel and Yanni. Or what was the other one? Like Brainstorm and something and Brainstorm. Remember those? It's kind of one of those. Ate too many drugs, ain't do any drugs. Pretty close. Pretty close. Good to see you, Sasha. No Doubt says, earlier in the trial, Nelson made the point with the girlfriend that he had been clean up until 2 weeks before the event. Is Nelson likely to bring that back up to contend that 11 nanograms would be more significant for someone that had recently been clean and reduced their tolerance? Good question, No Doubt, right? If you are a regular user of a particular drug, your body builds up a tolerance and you need more to get the same effect. If you are clean for 2 weeks, that tolerance level goes down. Now, if you use at the same amount, your body can't tolerate that anymore. So that same amount that you were using maybe last year or 2 months ago is now lethal. It wouldn't have been, but it is now. Maybe that's coming out from Mr. Nelson. We'll see. Liberty or Death says, Rob, it was not the best day for the prosecution. I'm more and more impressed by Nelson. Has me wondering, though, do you think Attorney General Keith, no means yes, Ellison, is saving himself for Chauvin? It's a good question. I don't know. I don't know. It's a good question. I don't know what the answer is. I think that would be very fun. It would be very interesting. Yeah, I agree. Not the best day for the prosecution, but they kind of have to work through this stuff. Like this has to get out and they have to be the ones to do it. And so they're doing that. So it's like, when you get back into the gym, when you start working out again, you've been lounging, just getting fat and unhealthy all Thanksgiving, all Christmas, and you got to go back in. You're going to have a little bit of a hell week. It's going to be rough, but you got to get through it in order to get the benefits. Kind of what the prosecution is doing. They have to get this stuff out, and now they're going to have to transition into more of the cause of death stuff, and we'll see what that looks like. J-Bone says, what are your thoughts on the pill evidence not being found until December and the defense having to request a squad car search to find the pills in the squad car? Seems like a very sloppy job by the state to me. I don't see how it's reasonable to not look into drugs in the car after the toxicology report came out. Yeah, so J-Bone's talking about, I think her name was Mackenzie Anderson. She testified today. She was the person who received the car. So she goes in, she's doing an inventory of the car, opens up the squad car, sees the shoe, moves the shoe, sees a pill. Wasn't asked to look for a pill, she said. Well, it wasn't on my list of things to look for. I was inventorying the car. I was looking for other things. That was there. I just thought, it's just a pill. It may have come off of somebody's shoe, may belong to somebody else. No idea. Which to me is very sloppy, right? This is something that absolutely should have been looked into. She didn't do that until Nelson comes back and says, hey, maybe we want to look through that again. Then it comes up. It's a big deal that there's a pill back there that allegedly has some fentanyl in it. We're going to hear what Nelson's people have to say about it. Next up, we've got OSOC. Rob, question. So could you get around the hearsay rule if someone viewed the video of interviews with other officers afterward and then talked about what they saw on the video? Would that be admissible? I've heard this could be a workaround. So no. So the hearsay rules are extremely complicated. You have hearsay, you have things that are not hearsay, and then you have exceptions to hearsay. The whole thing is very convoluted. So it just depends on what you're trying to talk about and what purpose it's being admitted for. So there are more rules than that. It's not that simple, in other words. But generally, the answer is no, right? If it's an out of court statement that is being made and asserted to prove the truth of the matter, that type of stuff is not going to come in because you have to think about the best evidence. What is the best evidence of that you're trying to get into court? Is it somebody talking about the video or is it the video? It's really the video. And that's going to provide more evidentiary value than somebody talking about what they saw on the video. Now, if that person was there and in the video, they're an even better witness because they were there. And we can cross-examine that person. So there's different rules for video and audio evidence and all that stuff. Good question. Very complicated answer. Next up, we got Anki Woe says, doesn't the prosecution have depositions and or prep the witness with their questions before trial so they know beforehand how their own witness will answer? So kind of. Yes. So not really prep, right? You can't prep your witnesses. You can't coach them, is where that is kind of going. But yes, you can have conversations about it. You can interview them, and the defense wants to see that stuff. They want to be available. That needs to be available for the defense, because you don't want a situation where people are improperly prejudicing a witness. Now, I think that there were something like 400 witnesses in this case. So Mr. Nelson may not have been involved in all of them or even cared to be involved in all of them, but presumably he would have been in the ones that he wanted to communicate with. And you've seen this in court, right? He comes out and he says, he was actually talking about this with Jody Stiger today. He said specifically, how many times have you met with the prosecution? Oh, and you met with them last night also, right? He knows about it because he was probably informed about it. All right, couple more. The Red Dragonfly says the last scientist must do the 90 to 100% for the cartel. So she was the forensic person. And then lastly, we have Jack Elias says, is it possible that the training of the police to observe the totality of the circumstances were overwhelmed by doing so, and therefore the public involvement contributed to the failure of the officers to be able to act in a more focused manner because of that training? Yeah, I think you can make that argument. I don't know that that negates any potential criminal liability, but yeah, you can make that argument, right? And even Chauvin could say, listen, I would have rendered aid, but there were 17 people out there screaming at me. And we had the one guy who was saying, you're a punk, you're a B, you're this, I'll come at me, I'll hit you, right? So there were some threats or close threats that were being levied their way at the time. And maybe that caused them to elevate their response and not render aid. It's one justification, right? And I'm not saying that that's the right thing to do. I'm not commenting on that. When I make those claims, I'm just sort of exploring the arguments from different perspectives. And that is one that I think might be relevant. So very good questions. Once again, those came all over from watchingthewatchers.locals.com. And we invite you to come and join us there because we got a great community of people and we want you to participate in the show. It's a good platform to be on, watchingthewatchers.locals.com. A lot of other great creators over there as well. So go check that out. All right. So that's it on the Chauvin stuff.